In this lesson, we will discuss business contracts and agency relationships. By the end of the lesson, you should be able to discuss business contracts and explain the concept of agency law. A contract is a promise or agreement between two or more legally competent parties. In order for the contract to be legally enforceable, it must include the following elements. There must be an offer by one competent party and an acceptance by another competent party with evidence that the parties intended to be legally bound. Something of value needs to be given in exchange for the promise to perform. This consideration does not necessarily have to be money. It could be real estate, a future promise to perform, or even an exchange of affection. A contract whose purpose is to commit a crime is not enforceable or legal. An enforceable contract must be of legal purpose. The parties must be able to contract per state law, i.e. it's legally competent. Examples of parties that are not considered legally competent are minors, mentally challenged, intoxicated, or parties under duress. The contract must comply in form to legal requirements. For example, not all contracts have to be in writing to be enforceable. However, contracts for sale of real estate properties do have to be in writing. Some jurisdictions require contracts for sale of property over a certain dollar limit to be in writing in order to be legally enforceable. Not all contracts will stand up in a court of law. A contract must be found to be invalid if it can be shown that it, 1, misrepresented the terms of the promises, 2, was signed under undue duress, coercion, or influence, or 3, was based on a genuine mistake due to ambiguities or mistaken information. A contract that lacks one or more of the elements discussed on the prior slide, offer and acceptance, consideration, legal purpose, competent parties, and legal form, is a void contract. A contract that gives one or both of the parties the option of voiding it is called a voidable contract. For example, in some situations, a minor can be party to a legal contract. However, the minor will have the right to void the contract up until reaching the age of majority. In this situation, the voidable contract is considered legally enforceable, but because there's a minor, it's treated as being non-binding on the minor from the day it was signed. There are numerous types of contracts. Each form of contract fulfills a need for a particular industry or business. In some circumstances, laws may apply to the contractual relationship. For example, commercial contracts for the purchase of goods or products in many states fall under the contracting laws of the Uniform Commercial Code. Similarly, the real estate industry has its own state-approved contracts. Contracts that financial planners tend to deal with include unilateral contracts. The unilateral or one-sided contract is one in which only one party, the offeror, promised to do something in exchange for the other party, the offeree, performing some action. A life insurance contract is an example of a unilateral contract. The insurance company promises to pay the benefit amount to beneficiaries according to the terms of the contract if the insured makes premium payments. Once the insurance company is legally required to fulfill their part of the contract, the insured can stop making premium payments at any time and walk away. Bilateral. The bilateral or two-sided contract is one in which both parties promise to do something or promise to refrain from doing something. The buy-sell agreement is an example of a bilateral agreement. Once the contract is entered into, the seller is legally bound to deliver the property, and the buyer is legally bound to complete the deal. Neither party can walk away without the other party's approval. A conditional contract. A conditional contract is similar to the unilateral contract. However, the offeror is only legally required to perform if the offeree fulfills certain conditions. For example, in order to attract high quality management, companies offer a lucrative deferred compensation package. The only stipulation to the deferred compensation promise is the requirement that the manager is still employed with the company. A contract of adhesion. Adhesion contracts are drafted by one side as opposed to being negotiated by both sides. The offeror prepares all details and wordings of the contract. The offeree has the option of taking it or leaving it. An example of this is a standard homeowner's policy, for example, the HO3 policy. A contract of indemnity. A contract in which a person or company promises to cover any financial losses in the contract of indemnity. The amount of the reimbursement is designated to make the person whole, less any limits, deductibles, or copays. The indemnified should not profit from the recovery. Examples of contracts of indemnity include property insurance, liability insurance, and health insurance. Non-performance of promises or obligations is referred to as a breach of contract. If a breach of contract occurs, there are a couple options. First, the second party can walk away from the contract. Second, damages may be awarded. 3 categories of damages for breach are compensatory damages, punitive damages, and liquidated damages. Compensatory damages cover direct economic loss associated with the breach. Punitive damages may be awarded over and above that compensatory amount. These damages are awarded to both punish the offender and to clearly communicate to the public that this type of action is not going to be tolerated. Liquidated damages predetermine the economic value of the breach. For example, in a real estate transaction, the liquidated damages for failure to perform might equal to the amount of deposit held in escrow. Note that the death of one person to the contract ends any contract required future service. However, it doesn't negate a contract that calls for the delivery of product or real estate holdings. Contracts that financial planners tend to deal with include the financial planning engagement letter, loan agreements such as mortgage loans, credit agreements such as credit card agreements, insurance contract, and business partnership contracts. Agency relationships are necessary and quite common in our society. An agent is a person authorized to act on behalf of another, such as an agent and the employer, an agent and the client. Examples of agency relationships are employers and employees, employers and independent agents, financial planners and clients, insurance company, and their agents. An agent is granted authority to represent the principal in 3 ways: express authority, implied authority, and apparent authority. Express authority is often given as a written contract or communicated agency agreement. The agreement details what authority the agent has and doesn't have. It's clearly written out. Implied authority is a type of authority that is consistent with the work being performed. For example, an insurance agent sitting in the office with business cards and company pricing material would obviously need to have the authority to write contracts for the insurer in order to do his or her job. Apparent authority takes the concept of implied authority just a little further. In this situation, all the person has to do is give the appearance of being an insurance agent based on actions and appear to be a reasonable third party that he or she is working within the scope of the job. Note, if the non-authorized action of the agent is accepted by the principal, then the action is ratified. Both sides in an agency relationship have duties. These include the duties of the agent, including loyalty, duty not to be negligent, and to represent the principal in a professional manner, duty to obey reasonable instructions and to only act within the scope of authority, and not to receive benefit that's detrimental to the principal. On the other hand, the duties of the principal: pay the agent for the services rendered, meet contractual obligations, and to be liable for all torts committed by the agent that fall within the scope of the job. A conflict of interest could arise if a person simultaneously serves multiple principals. For example, consider the financial planner who's affiliated with the broker-dealer and is working for a client in a financial planning engagement. In this situation, it's important to promote full transparency and to uphold high practice standards. Advisors and planners are required to act in the best interest of their principal and their clients. Acting in the principal's best interest means putting the client's or employer's needs above your own. In putting the client's interest first, it's important to consider suitability. FINRA defined suitability as the appropriateness of an investment product in meeting the needs of the client. In an earlier video, you learned about the CFP Board's fiduciary standard. You also learned that investment advisors falling under the Investment Advisors Act of 1940 are also held to the fiduciary standard. CFP Board's Code of Ethics states, "A certificant shall at all times place the interest of the client above his or her own." When the certificant provides financial planning or material elements of the financial planning process, the certificant owes to the client the duty of care of a fiduciary as defined by the CFP Board. The CFP Board defines fiduciary as one who acts in utmost good faith, in a manner he or she reasonably believes to be in the best interest of the client. In this lesson, you learned about business contracts and agency law.